Okay, great. Well, hello, everyone. My name is Brendan McCauley. I'm the Head of Account Management here with CFRA. I'd like to welcome you to today's webinar on CFRA Legal Edge on Qualcomm, the FTC case, the Apple Battle Royale, and where Qualcomm goes from here. Before we get started, I just wanted to remind you that today's session is being recorded, and a link to the recording will be made available within the next few business days. During today's session, you may submit questions using the GoToWebinar panel, and we will do our very best to answer as many of these questions as we can. So we're excited to have with us my colleague Nicholas Rodelli. He heads up CFRA's Legal and Regulatory Research Team, which we call Legal Edge. Nick has led CFRA's Legal Edge team for 12 years, and he has a strong track record of actionable calls on Qualcomm at major inflection points over those 12 years. This includes an 80% hit rate and 28.8% average alpha. And he's closely followed the FTC versus Qualcomm trial, the Apple versus Qualcomm San Diego federal case, and related litigation. Next slide, please. So for those of you who may not be familiar with CFRA, I just wanted to provide a quick background. CFRA was founded in 1994, over 25 years ago, as a forensic accounting-focused independent research shop. In 2006, Nick Rodelli joined us and launched our Legal Edge research service. At the end of 2016, we acquired the fundamental equity and fund research business from S&P Global and have now, as a combined business, over 90 years of experience as an independent research firm. Here you can see CFRA's mission. The key terms really here are independent and actionable. So we don't provide banking services, we don't have a trading desk, we don't manage money or provide corporate access. And so the goal really of everything that we do, and our primary motivator, is to be a valuable and unbiased resource for our clients, an extension of their investment process, and to help them save and make money. And so how do we do this? Well, our forensic team offers a few distinct services. As I mentioned, we started as a forensic accounting research firm and continue to be the gold standard in accounting-focused research. Our biggest concerns list, which is the primary output of our accounting lens research product, is a curated list of actionable short ideas with a 12-plus year track record of significant alpha generation and risk mitigation for our clients. Nick Rodelli, the star of today's show, heads up our legal and regulatory product, and he will dive deeper into this later in the presentation. But as you can see here, the key points of that product are idea generation, live court coverage, risk monitoring and alpha generation, as well as an advisory type legal help desk. We also offer custom research and advisory services, training and seminars, and finally, all of our teams produce quality, industry, thematic, and educational research. Please feel free to reach out to us, set up a call or meeting if you want to learn more about any of these services and discuss whether we might be a valuable resource for your firm. That ends up my overview here, and with that, I would love to hand it over to Nick.
All right. Well, thank you, Brendan, and good morning, everyone, and thanks to everyone on the line for taking the time to listen in. We have a lot of ground to cover in about 30 minutes, so I'm going to just jump straight into it. First, starting out with our track record and approach to Qualcomm. So Qualcomm has been a big name for us since Legal Edge's inception in 2007. We've had 5 actionable calls on the company, 2 long and 3 short. 4 of those 5 calls produced positive alpha of at least 20%, with average alpha across all calls, including 1 misfire of, as Brendan alluded to, around 28.8%. So our positive thesis on Qualcomm in 2008, just as an example, was tied to our view that then Delaware Vice Chancellor Leo Strine would bring a fractious dispute between Qualcomm and Nokia to a compromise. And the judge was able to do that by emphasizing downside risk faced by both sides if there was a binary court-ordered outcome. We attended all of the pretrial hearings, and we watched Vice Chancellor Strine beat both sides into submission, and still vividly remember how on the first day of trial, The story out of the Delaware Chancery Court clerk's office is that the trial had been delayed because of a supposed technical difficulty, when in fact the parties had just pulled an all-nighter and they had ironed out the details of a settlement which was announced later that same day. So why do we say here that Qualcomm is the large cap special situation? There are a few factors. First includes legal complexity. Also, there's ongoing and dynamic interaction between legal and fundamental drivers. There's also the need for a holistic analytical approach. And finally, our experience is that the market tends to be behind the curve with Qualcomm in anticipating what's around the corner, what comes next. All right, so just moving to an overview of the three main areas of litigation that Qualcomm's involved in. That would be first the FTC Qualcomm case, second would be the San Diego litigation with Apple, and then third would be the bucket of cases around the world, the individual patent infringement cases. So first starting out with what we view as the main event. We actually see this case far more significant, frankly, than any of the others with the FTC with the Apple Qualcomm San Diego case as the second most significant. So just spending a little time here on the FTC case. I assume everyone on today's call is well aware. We're waiting now for San Jose Federal Judge Lucy Koh to come out with her post-trial ruling in the FTC's blockbuster lawsuit, the antitrust case against Qualcomm. So the trial was held in January, and while a decision could come at any time, our central tendency on timing is around late March into early April. So just kind of stepping back and looking at this case in the timeline, the risk picture in this case darkened considerably for Qualcomm last fall, when Judge Koh surprisingly rejected Qualcomm and the FTC's joint request for a delay of an important pending ruling. The parties had asked the judge to hold her decision to allow the parties time to negotiate a settlement. Judge Koh rejected that, which is, to put it mildly, is very unusual to see a judge reject a request by parties to allow them to have settlement negotiations ahead of a decision. And so shortly thereafter, Judge Koh issued her partial summary judgment ruling. In that, she found that Qualcomm is obligated under its FRAND commitment to license its standard essential patents to all comers, including chip competitors like Intel. We believe this ruling probably hardened the FTC's position, or at least made it more difficult for the FTC to agree to a settlement that might be criticized as being soft on Qualcomm. At the January trial, Judge Koh's treatment of Qualcomm and Qualcomm's lawyers was incredibly harsh in our view. And we think that possibly could be due in part to Qualcomm's unsparing criticism of Judge Koh in an appeal by Qualcomm of Judge Koh's certification of a nationwide class of smartphone owners in a private antitrust lawsuit against Qualcomm. This is a case that was piggybacking on the FTC's lawsuit against Qualcomm. In any event, the FTC's case against Qualcomm is a reminder of the role of luck, whether good or bad, in high-stakes litigation. The FTC case was brought on a 2-to-1 vote in the waning days of the Obama administration. Qualcomm probably thought it could win a favorable compromise with the change in administration and with a new majority Republican vote at the commission. Qualcomm's confidence probably was amped up further after CFIUS's intervention on Qualcomm's behalf in the Broadcom takeover situation. But here's where Qualcomm's luck kind of turned south. We were at the Georgetown Antitrust Symposium when the new FTC chairman disclosed for the first time that he was recused from the Qualcomm case. That meant, suddenly, that Qualcomm would now need to persuade at least one of 2 Democrat commissioners to accept a settlement, a much taller order in our view. Coincidentally, or not, the timing of this recusal development overlapped with when settlement negotiations between Apple and Qualcomm reportedly broke off in the 3rd quarter of last year. So in terms of Judge Koh's upcoming ruling, while the consensus view is that the FTC has a strong case and Qualcomm's likely to lose, we see significant weaknesses in the FTC's case, including nearly non-existent econometric evidence and overbroad remedy demands, and think there is a possibility that Judge Koh surprises everyone with her ruling, although that is not our base case. However, there is a wide range of possible outcomes, especially when it comes to remedies. You may know the outer fringe of the FTC's remedy demand would require Qualcomm to exhaustively license its standard essential patents at the component, i.e. at the baseband chip level. Finally, we think that the aftermath of Judge Koh's ruling will give rise to a number of important questions, including whether Qualcomm can obtain a stay pending appeal, and the extent to which Judge Koh's ruling could limit Qualcomm's ability to relitigate certain issues in separate disputes with Apple and with others. Moving on now to the San Diego case. This is the major theater of direct hostilities between Apple and Qualcomm. This is where antitrust, breach of contract, patent exhaustion, and a myriad other issues are teed up in front of a federal jury before Judge Gonzalo Curiel, beginning on April 15th. So this trial is expected to run about 4 to 6 weeks, and it is an incredibly unwieldy case with a wide range of issues, most of which will be tried to a jury, a few of which may be tried to Judge Curiel. And there's been some significant tactical gamesmanship in this case. Apple successfully delayed this case, making several different motions to delay discovery and other tactics that resulted in this case being slotted in time behind the FTC case. And we think Apple did that to maximize leverage over Qualcomm and to hope to parlay a possible FTC win into a win for Apple in the San Diego case. Qualcomm, for its part, flexed its tactical muscles when it eliminated a number of Apple's patent exhaustion claims by providing Apple what's known as a covenant not to sue on a group of patents that Qualcomm originally asserted in the case. Okay, now moving quickly to the third area of litigation, and this is the one-off infringement cases. These are pending all over the world. We have several U.S. federal court cases. We've got 2 U.S. International Trade Commissions, over 20 cases in China, et cetera. The vast majority of these cases involve Qualcomm offensive patent infringement claims against Apple on non-standard essential patents. There are also a few stray cases where Apple is claiming infringement by Qualcomm. So the way that we think about these cases is to look for major trends. We don't get overexcited about headlines in any one particular case. So for example, can Qualcomm string together a series of wins yielding injunctions that cause meaningful pain to Apple or chip away at Apple's carefully crafted public image? Or more significantly, will China leverage the opportunity provided by Qualcomm's litigation against Apple to address long-standing complaints about China's weak IP protections? These actions, if China does that, could coincidentally, of course, give a leg up to Apple's Chinese OEM rivals, such as Huawei. So we see this as an area to closely monitor. Lastly, just of note in this bucket of individual cases is an upcoming U.S. International Trade Commission ruling, which is currently set for March 26th. This is the first of 2 Qualcomm versus Apple cases in the ITC. Okay, now moving on to sample FAQs that have come up in our conversations over the last several months. I'll note that earlier this week we published a new report covering 10 additional FAQs that we won't get into today on issues such as the prospects for an FTC Qualcomm settlement, the probability that Qualcomm wins a stay in the FTC case, and the extent to which Qualcomm may have leverage over Apple, to name a few. The first up here is, what do we think about the late January short seller report on Qualcomm? So I won't on this call or in this context quarrel or challenge the short report's analysis regarding how the FTC Qualcomm case may turn out in terms of Judge Koh's decision. What I'll focus on instead is the use in that report of $1.50 per device as a supposed base case as a royalty in the event of an FTC win. We think that that's far too draconian. It is widely known, for example, that Nokia and Ericsson collect something in the range of 50 to 60 basis points per device. They've also proposed royalty caps that when you combine both 5G and backwards-looking compatibility licensing would be even higher than the 50 to 60 basis points. So it's difficult for us to imagine that Qualcomm ultimately achieves lower per-device royalties than Nokia and Ericsson. Also, the short report suggests application of a high single-digit aggregate royalty rate, that is, combining all royalties assessed by all holders of relevant standard essential patents, taking that and applying it to the $20 price of a baseband chip, as opposed to applying that to the device, which is what all analyses in this area have always assumed. So we think that those assumptions are far too aggressive and frankly don't make much sense. We also point to media reports that Apple sought to pay around $4 per phone in royalties to Qualcomm in a renegotiation, and that's about a 60% rate reduction versus the $10 per phone royalty rate net of rebates that Apple was paying previously. To us, this seems to be a more reasonable downside case assumption in the event everything goes sideways for Qualcomm. Given the sensitivity to Qualcomm's financial model to royalty rates, Qualcomm's fair value under this analysis in the January short report, holding all other assumptions in that report constant, changes from $21 per share to around $55 per share when using $4 per device rather than $1.50 as the base case royalty assumption, and jumps to $63.50 when you add back stock-based comp into non-GAAP EPS. In addition, the short report assumes that whatever occurs in the FTC case will necessarily be of global effect, when that is far from clear in light of traditional territorial limits on FTC enforcement actions. Okay, moving now to the second FAQ. What did we think of closing arguments in the FTC trial? So I'll just take these, the FTC first and then Qualcomm second. So the FTC focused its closing argument on testimony snippets, by and large, from various Qualcomm licensees, each of whom claimed that Qualcomm's royalties are excessive. One notable aspect of the FTC's closing argument was the FTC's attempt to bolster its broad remedy demands, including its request for exhaustive chip-level licensing. While Qualcomm argues that it follows industry practice and has legitimate reasons to license at the device level, while not formally granting licenses at the chip level, the FTC wants Judge Koh to require Qualcomm to effectively re-architect hundreds of license agreements. You could say that this is tantamount to changing tires while driving. The government makes this argument despite having no evidence that Qualcomm ever threatened to sue rival chip makers, and notwithstanding evidence that Qualcomm believes that it couldn't license chip makers without running into patent exhaustion and royalty collection inefficiencies. Maybe sensing that its remedy demands are a bit of a stretch, at one point during closing arguments, the FTC's lead trial counsel allowed that, quote, if it turns out that it was more efficient for OEMs and Qualcomm to license at the device level without any chip supply leverage involved, then that's what would happen, and the FTC wouldn't stand in the way. Arguably, that is precisely what already is happening today, given that Qualcomm's baseband market power has substantially diminished, with Intel's rise and with Samsung making many of its own modems and SoCs. Further, we interpret this statement by FTC counsel as an indirect acknowledgement that the FTC's case, in essence, centers on alleged monopoly leveraging, i.e. that Qualcomm leverages its chip business to garner unfairly high royalties. It almost seems like the Apple exclusive dealing allegations and demands for exhaustive chip-level licensing are kind of thrown into the mix by the FTC to bolster their case. On a related note, since the crux of the FTC's case is about monopoly leveraging, we believe the separation of Qualcomm's chip and licensing businesses would address the bulk, if not all, of the FTC's real concerns. Notably, it was revealed at trial that Steve Altman, the architect of Qualcomm's licensing model, who's now retired, has long advocated for the separation of Qualcomm's chip and licensing businesses. For its part, Qualcomm's closing argument began with an effort to give context to what Qualcomm characterized as self-serving evidence from the company's licensees. Notably, this is one of the more difficult issues for Qualcomm, as Qualcomm didn't call any licensee witnesses to support Qualcomm's position that its royalties are in fact fair and reasonable. Qualcomm then moved on to a critique of the FTC's contentions and expert testimony as being inconsistent with real-world evidence. The company argued that device-level licensing is industry standard. Qualcomm noted a logical inconsistency in the FTC's position that Qualcomm is both strong on 5G and thus needs to be constrained by Judge Koh, but at the same time that Qualcomm's technology is washed up and deserving of much lower royalties than what Qualcomm was paid when it came out with its pioneering CDMA technology. Qualcomm also argued that its market position had been earned by engineering prowess and by simply making better products. The company noted that the FTC failed to establish any substantial competitive impact from the company's practices, and that mere theories of harm, including those offered by the FTC's lead expert, Dr. Carl Shapiro, are just not enough. As to Shapiro's analysis, Qualcomm criticizes its failure to even attempt to quantify the extent of any alleged Qualcomm tax, and also that the FTC offered no proof at all that Qualcomm, in fact, raised its rivals' costs. As an aside, it is noteworthy that Shapiro's expert opinion came in for similar criticism in the AT&T Time Warner case for being long on theory and short on real-world evidence. That opinion was ultimately rejected by Judge Leon, whose decision in the AT&T Time Warner case was upheld just yesterday by the D.C. Circuit Court of Appeals. Other arguments from Qualcomm and closing arguments. They also noted that they have never in their history granted exhaustive chip-level licenses, and thus that the company has not stopped any prior practice that it engaged in with any kind of malice, any kind of anti-competitive malice, which is what the law requires in this context. Qualcomm further noted that the smartphone and baseband chip industry is thriving, that output has skyrocketed, and that chip prices are declining, while at the same time, Qualcomm's market share in the chip business is also on the wane. As to alleged threats to withhold chip supply, Qualcomm argued that the FTC's evidence was limited to snippets from Qualcomm emails and other stray documents that were taken out of context and presented in a misleading way. For our part, we frankly were surprised at trial by the lack of any smoking guns on this issue. The company also said that it has legitimate reasons to keep QTL and QCT together, including increasing Qualcomm's credibility between standard-setting bodies. Qualcomm finished up arguments by touching on the issue of remedy and Qualcomm's view that the FTC must justify its broad remedy demands based on current market conditions, not market conditions circa 2016, which was the cutoff used by Shapiro. Okay, so with that, I will hand the call back over to Brendan for Q&A.
Thank you, Nick. Clearly a very complex situation. We know that our clients value your nuanced and well-informed understanding of this all. So thanks for going through that very much, Nick. We do have time for a couple of questions before we close up here. The first question that we have that came through for Nick, do you think this is a bullish sign for Qualcomm the longer it takes for Judge Koh to rule?
That's a great question. delay could be good. It could be good for Qualcomm. Judge Koh is a very savvy judge. She has to be keenly aware of this looming trial between Apple and Qualcomm down in San Diego, again, which starts up on April 15th. So she also has to know that her ruling could have a big impact on that case. Apple is on the record in the San Diego case is saying that they're going to seek what's known as collateral estoppel, which is a fancy way of saying, Apple wants to bar Qualcomm from relitigating issues that have already been decided against it in the FTC case. So it's a bit speculative, but we would think that Judge Koh would want to rule before that trial starts, or at the very least rule before the case goes to the jury for deliberations. So if she does not rule before April 15th, it might be a sign that either she's reluctant to step in front of the San Diego jury, or that she's harboring some doubts as to the liability ruling or the remedy piece of the case.
Okay, thank you. And we do have a second question here that came through. Nick, you alluded during remarks earlier on the call to a range of important issues that will emerge after Judge Koh's ruling. Can you please elaborate?
Sure. I can at least outline several of the issues. So one key issue is, kind of going back, I think you mentioned this before, is the probability that Qualcomm can obtain a stay of the FTC ruling pending appeal. Whether that's from Judge Koh or from the Ninth Circuit Court of Appeals. So this is an issue we've looked at in a considerable amount of detail. The Ninth Circuit is, well known for being a bit unusual and unpredictable in a lot of different ways, and in another way, as applicable here, they have a unique set of rules and practices in this area in terms of seeking stays pending appeal. When you think of the significance of the issue, it looms large because a stay would delay the implementation of any remedy pending appeal, which means that the status quo would be largely preserved for, call it, the next 6 to 12 months, maybe even longer. And, that becomes particularly important if you assume, as many do, that Qualcomm gains incremental leverage in terms of negotiating leverage with Apple as Apple moves closer to kind of the decision deadline for figuring out who it's going to use as its first and second source for baseband for the 5G iPhone, which has been confirmed in multiple places, although obviously not officially by Apple, but we've seen it in the litigation, very specific references to an assumption of the fall of 2020 for the 5G iPhone. So also, just the stay issue, the stay of the FTC ruling could affect the San Diego case. You think about Judge Curiel and whether he would be willing to find that collateral estoppel is applicable. There's a pretty good argument that would be unjust if the FTC decision has been stayed pending appeal, which would imply that there's at least a fair chance that Qualcomm would prevail on appeal. And so to apply collateral estoppel in those circumstances arguably is not the right call for Judge Curiel. So that's another potential implication from the stay issue. So separately, another big issue here in the wake of the FTC ruling would be, again, collateral estoppel and its effect on the Apple Qualcomm case in San Diego. I mean, just more generally, apart from the stay issue, it's a big deal. I think it may be one of the reasons why Qualcomm is reportedly continuing to make a big push to settle the FTC case. And so those are two issues. A third that I'll mention again is just on the issue of remedy in the FTC case, that Judge Koh has a very wide range of things that she could do. And depending on specifically what she orders, that could have a very significant impact on just how material that outcome is to Qualcomm's business model. Okay, so I think this is from my part here, Brendan. I'll just, before we close this session, I just wanted to go over a few quick words about Legal Edge. So there are two main components to the product: research reports and alerts, and then what we call counsel on call. That's where me and the team are available to answer questions on covered companies and also just one-off client questions on situations that we're not covering. So we take a generalist approach. We cover all sectors and most legal issues, although we tend to be more active in TMT. There are a few areas also that we don't tend to get involved in, such as distressed and complex chemical compound pharmaceutical patent litigation. But other than that, everything is fair game. So just to give a flavor, a couple of situations of special focus right now would include, in addition, obviously, to Qualcomm, Henry Schein and Patterson companies over in healthcare, Bayer AG and its Roundup-related product liability litigation, and over in the M&A patch, the Rent-A-Center litigation in Delaware Chancery, just to name a few. So just very quickly, we have a compelling batting average. We're, again, with a particular focus on risk management and identifying asymmetrical alpha opportunities. We don't tend to get involved in jury trials. It's a big pushback sometimes on legal is that, well, it's too unpredictable, and who can predict what a jury does? Very rarely will that be a centerpiece of our thesis. So what we instead do is we focus on situations such as judge-based decisions, where there are a lot more reliable inputs to the analytical process. A lot more rigor is available in that context. So our coverage in terms of market cap tends to be concentrated in mid, large, and mega cap names, although we do cover smaller cap situations that are particularly compelling from time to time. All right, just wrapping up before we close, I just wanted to quickly mention our next webinar, which is scheduled for March 5th. It comes from our ETF and fund research side of the house, and my colleague Todd Rosenbluth, CFRA's Director of ETF and Mutual Fund Research. We'll go over our unique holdings-focused approach to rating ETFs and highlight some case studies where lower priced or larger ETFs performed very differently from similar sounding peers. During that session, you'll also hear from CFRA's leading equity analyst who will discuss the fundamentals of the sectors and industries behind some of these funds, including technology and industrials. We'll have a link for this session that will be sent to you this afternoon, along with a replay of today's session. So on behalf of everyone here at CFRA, we would like to thank you for taking the time to join us today. Within the next day, you'll receive a note from us with a link to the replay and with the slides from today's call. In the meantime, if you have any questions, please don't hesitate to contact us at cservices@cfraresearch.com. Thank you.